Response to number 80. Retaliation, obstruction of court access. Plaintiff alleges retaliation and obstruction of official processes based on his prior litigation history and protection order activity. The elements of a First Amendment retaliation or access to courts claim are not met. 1. No denial of court access. An access to courts claim requires actual injury to a non-frivolous legal claim, government action that hindered filing, pursuing, or defending a case. Here, no one prevented plaintiff from filing lawsuits. He filed federal litigation in Illinois. He filed federal litigation in Colorado. He filed multiple TROs and PPOs. He attended hearings. He pursued appeals. That record demonstrates continuous court access, not obstruction. Number 2, representation in prior litigation. In Fredrickson v. Landeros, court records reflect attorney representation during portions of the case. A litigant represented by counsel cannot plausibly claim systemic intimidation prevented court participation. 3. Pro se status was voluntary. In Fredrickson v. Larimer County, plaintiff proceeded pro se by choice. Voluntary self-representation is not state interference. A litigant's strategic decisions do not convert into constitutional injury. No retaliatory causation. To establish retaliation, plaintiff must show 1. Protected activity, 2. Adverse action that would chill a person of ordinary firmness, 3. A causal connection, i.e. the adverse action would not have occurred but for the protected activity. The harassment citation arose from conduct observed during a 911 response and traffic stop, not from filing lawsuits. Probable cause defeats a retaliation claim. If officers had an independent, lawful basis to cite plaintiff, the retaliation theory fails. No actual injury. Identified plaintiff must identify. A missed filing deadline. A dismissed claim caused by intimidation. Inability to serve process due to government interference. Loss of a meritorious case because of obstruction. Instead, he continued filing, continued live streaming, continued seeking court relief, continued appealing. There is no concrete legal injury traceable to municipal action. 6. Protection orders do not establish obstruction. The fact that some protection orders were granted, some were denied, one was reversed on appeal, shows judicial evaluation, not systemic retaliation. If the record demonstrates inconsistent or exaggerated factual claims in protection order filings, that undermines credibility, but it does not establish government obstruction. 7. Pattern of litigation is not immunity. Frequent litigation does not insulate a party from enforcement for independent conduct. Filing lawsuits and protection orders does not create immunity from criminal statutes governing harassment or related behavior. Bottom line, no court access was denied. No actual injury to a legal claim is identified. Probable cause defeats retaliation. Pro se status was voluntary. Representation existed in prior litigation. Judicial review occurred repeatedly. The retaliation/obstruction claim lacks the essential elements of causation and actual injury and is legally insufficient.